Good afternoon. Happy Wednesday. When you want to appeal the outcome of a trial, generally speaking, you have to preserve the issues for appeal by making the appropriate objections at trial. There are some things that you could appeal that you don't have to object to at trial. For example, ineffective assistance of counsel. But generally speaking, especially for evidence, any evidentiary issues, in order to appeal them, you have to preserve them by objecting at trial. So, one case that Chilli likes to talk about is Rodriguez versus the United States, which is a classic example of someone preserving the issue, an evidentiary issue, for appeal by objecting to it, and I believe there was a motion to suppress. So I don't even think it actually got to trial, but it's essentially the same thing. A motion to suppress is basically objecting to the evidence prior to it being offered for admittance at trial. So in Rodriguez versus the United States, the underlying fact pattern is Rodriguez was driving. There was some minor traffic infraction. He got pulled over. The officer issued a citation. Traffic stop is done. There's no longer any reason for the officer to detain, delay, seize that driver. But the cop didn't let him go. The cop made him stay there until the cop got another unit out with a traffic dog, or with a drug dog, to do a drug sniff. The dog said there was some sort of drug in the car. Next thing you know, Rodriguez is hauled in front of the court on drug charges, right? Rodriguez had an attorney, a good attorney, an attorney who said, "Excuse me, I am going to move to suppress all of the evidence found as a result of the detainment after the citation was issued. After all of the reason for the stop had ended, it was a Fourth Amendment violation to continue to hold Rodriguez. And so all of the evidence that the government found as a result of that violation of the Fourth Amendment, all that evidence should be suppressed, not allowed to be admitted at trial, not allowed to be presented to the jury." Well, the trial court said it was a minor. They only held him for, the stop was justified, and they only extended the stop for like 15 minutes or something like that, so it was fine. Well, the appeal went up, and the Supreme Court said, no. The Fourth Amendment requires that you have, at a minimum, reasonable suspicion to detain someone. You had probable cause or reasonable suspicion. I don't remember which one it was. Doesn't really matter. There was at least reasonable suspicion. If a citation issued, there was probable cause for the initial stop. There's no problem with the initial stop. But once that initial stop was resolved, then you have to let him go. There's no longer any you're violating his constitutional rights to detain him after that point. So it has to go back down to the trial court. The trial court has to suppress the evidence. Most likely at that point, the government said, phooey, we can't win because we no longer have any evidence to present to show that he actually had the drugs, right? Most likely. So how does that apply to Chilli's case? Well, number one, Chilli didn't file a motion to suppress any evidence. That's problem number one. Nor did he object to the presentation of any evidence. That's problem number two. Problem number three is that Chilli wasn't detained at a traffic stop. Well, Chilli was detained at the location where another person had been detained in a traffic stop, but Chilli was being detained for something entirely unrelated. So the traffic stop had a different person, different probable cause for the stop, and it finished. The cop said, you can go. The cop didn't drag out that traffic stop after he wrote a ticket. That traffic stop had ended. His interaction with Chilli is an entirely different animal. Different person being detained. Different probable cause for the detainment. And it didn't end with anything beyond, well, once we've wrapped everything up, you're in cuffs. It didn't get extended. There was no traffic dog brought out. There's no drug sniff dog brought out. Like if they had wrapped everything up, with Chilli, and they said, here's your citation for obstruction, whatever. Here's your court date. You're all good. Oh, but wait here. We're going to call a drug dog down to have him sniff your car before we let you get back in it. Well, that would most likely be a violation of Chilli's Fourth Amendment rights. Anything they found as a result of that search would most likely be able to be suppressed by a proper motion or objection. But notice that none of the things in Rodriguez really apply to Chilli's case. Rodriguez was pulled over on a traffic stop. Chilli was detained for interfering with a traffic stop. One was detained for a traffic violation, so he is the detained person in the traffic stop. The other one was interfering with the detained person in a traffic stop. Totally different situations. And I'm sure that in Chilli's mind, Chilli was a part of that traffic stop, which really, when you think about it, undermines Chilli's whole position that he wasn't interfering with the traffic stop. But if he's part of the traffic stop, how is he not interfering with it? If you, some random person, walk up to and interject yourself into a traffic stop to the point where you become part of the traffic stop, how are you not interfering with it? I don't know. But in Chilli's magical world, he probably wasn't. He was both part of the traffic stop and not interfering with the traffic stop simultaneously. Magic. But you get my point. I'm not going to beat it to death. Rodriguez doesn't apply for all the reasons mentioned above. There was no motion to suppress evidence. The stop, Chilli stop, was not delayed for them to bring in a drug dog or what have you. Chilli stop ended with him going to jail. It didn't end with a citation and then they held him for anything. I mean, it just doesn't apply. And whatever Chilli tries to make out of it, it's not going to get anywhere at the Court of Appeals. It's just not. The thing with Fourth Amendment violations is you have basically two recourses. One, you could sue under 1983 for monetary damages, maybe injunctive relief, maybe. Number two, you could suppress evidence. Now, neither of those mean that you get away with the crime you committed. The suppressing of the evidence might make it impossible for the state to prove beyond a reasonable doubt that you committed the crime, but it's not a, hey, I get to commit the crime and not have to face any consequence for it. There's no rule that, well, the state fucked up too, so, two wrongs make a right, and, we both go our own separate ways. It's, here's your remedy if the state fucks up. If the state fucks up, you could sue for under 1983, or you could do a motion to suppress evidence, or a combination thereof. If you fuck up, well, you're going to pay a fine or do time or both. That's the way it works. Welcome to the U.S. I hope you enjoy your stay. Thanks for watching. Have a great day.